Well, good morning, everybody. Welcoming everyone to the MG&E rate case party session. Just be waiting for people to join us, and I'll be adjusting screen names while they do that. I'll try to start at 10 o'clock, and we'll be live streaming as well. So,
Your Honor, we're trying something new here. I just want to make sure you can hear us.
yes, yes. How about on your end? Can you hear me okay?
Yes, thank you.
Okay, great. Well, good morning. The more of you joined, I'll just restate that this is the MGE party hearing session. Just checking people in, getting their screen names um, in, in order here, and we'll be starting soon. Have someone in the waiting room named Brandon Cosgrove. I don't recognize that name, but I may be forgetting.
He's IBW 2304. Should be on the
Oh,
list.
okay,
Right above me, I believe, on the list.
okay, that's fine. So I'm getting an echo through your connection. Is it Nathan? All right, so we're past due. Still people were joining us. Looks like we have all the parties represented here. Connections have slowed down a bit. Yeah. Another minute here and we'll all right, looks like we're good to go. So let's get on the record. This is docket 3270 UR 126, the application of Madison Gas and Electric Company for authority to adjust electric and natural gas rates. My name is Michael Newmark, the administrative law judge for the PSC. We're connected on Zoom for the party hearing session. We will receive evidence from the parties and commission staff. We are live streaming on YouTube, so we invite the public to observe the hearing through that form. And we're taking public comments in this case up until October 2nd, either through the commission's website or by US mail. Written comments are collected that way. We'll be conducting a public hearing session September 30th at 2 p.m. and then again at 6 p.m. at the PSC hearing room in Madison, where we can receive live spoken comments and also comments in writing that can be handed to us at that location at that time. So this point, just let's go off the record for a minute. Let's let some people in here. Okay, let's get back on. So we'll do our appearances on the record, then we'll move to our normal state of affairs, reviewing filings on the offered evidence list, etc. And we also have a pending motion from BPSA that we can also discuss before we take our first witness. So let's start with appearances. First, we have BPSA, who's appearing for that organization.
Morning, Your Honor. It's Krista Westerberg and Eduardo Castro from Pines Back appearing for BPSA.
Okay, thanks. And Citizens Utility Board.
Good morning, Daniel Narby appearing for Citizens Utility Board.
The IBEW.
Good morning, Nate Rasmussen and Brandon Cosgrove appearing for IBW 2304.
Thanks. MG&E.
Good morning, Your Honor. For MG&E, Brian Kleinmeyer from Stafford Rosenbaum.
Okay, the PSC.
Good morning, Judge Newmark. Michael Garcias is a general with the PSC, and with me is Deputy General Counsel Evan Whites.
Great, thanks. Renew Wisconsin.
Good morning, Your Honor. Sharif Halawish appearing for Renew Wisconsin.
All right, and WEAG.
Good morning, Your Honor. Steve Heinzen appearing for WEAG.
All right, looks like we're good to go with our service list. Thanks for that. And let's get off the record then. We'll just discuss offered evidence list. First phase of this discussion is any errors or omissions on the list. This will be the list that will receive these documents into the record pending their verification and corrections. That'll be filed through the refiling process within 3 working days. Screen I have in front of me has pretty low resolution. I don't know if people can rely on the screen share for this, but this is the Word version of the document I sent out. This was Sunday night, like with a PDF. So let's just go through the list. Are there any errors or omissions in this list? Starting with the applicant.
No, Your Honor, the list looked good to us.
Okay, and how about for BPSA?
Fine by us, Your Honor. Thank you.
Okay, Cub.
No issues from Cub.
Okay, IBW.
This looks good, thank you.
Okay, Renew.
No issues, Your Honor.
Okay, and WEAG. We miss,
There we go. I couldn't get the mute off. Yes, no issues, Your Honor.
all right, and commission staff.
No errors or omissions from Commission staff, Judge Newmark.
Okay, thanks. So then in terms of the comments, any questions about the comments, starting with the applicant?
Your Honor, just one clarification with respect to the rebuttal testimony from Mr. Bates on page 3. I believe it's lines 3 through 8 that you're referencing, where I think we have one reference to one docket and then a second reference to a second docket where we need to insert the language regarding the item cited herein is not recorded evidence unless separately offered as an exhibit.
Like that. So 3, yeah.
And we
Yeah.
can certainly do that. I just want to make sure we're looking at the right spot.
Yeah, I think that's right. Yeah, because you're talking about evidence outside of the case. Yep, that's right.
Okay. And then the direction on the exhibits is very clear. And then I do apologize for not filing that request regarding Ms. Monroe and I earlier, but we did file that yesterday.
Yep, I saw that. Yeah, just a reminder there. Okay, and that's a good reminder because that is a pending motion. We can just want to make sure we nail that up. Anything else from the applicant?
No, Your Honor.
Okay, so We'll continue with BPSA. No comments there. Singletary, any questions from Cub?
No questions.
How about Renew,
No questions, Your Honor.
Weeg,
No questions, Your Honor.
and Commission staff?
Your Honor, no error, but we will be refiling the PSC DRR exhibit to take into account the verbal data requests, verbal Muehlman's 1, and verbal Clark 1.
Okay, let me start me. All right, and that looks good. Okay, so let's get back on the record. So with the filings we've discussed, those filings are acceptable and will be entered in the record once they're verified. All the documents listed on the offered evidence list will be entered into the record pending verification and correction. We did have a pending motion from MG&E substituting witness Monroe Nye, or substituting witness Rob for witness Monroe Nye. Is there any
Your Honor, you had it correct. It's
Okay.
yeah, you had it correct the first time. Miss
First
Monroe
time.
Nye would be taking the place of Mr. Rob.
Yes, right, thanks. So any objections to that? To speak up, anybody? Okay, not hearing anything, so that'll be fine. And I think that's it for this. So let's move on to the motion from BPSA that was received quite recently. I guess that was yesterday after hours. So I did see the filing from BPSA regarding the public comments. It was discussed during the Wisconsin Power and Light hearing. That was docket 6680 UR 125 at the party session last week. I brought this up so that there would be enough time to discuss and have BPSA take any remedial action about the comments that we discussed. And I think for our convenience, I appreciate that BPSA did include that portion of the transcript in the motion. So I think that's useful here. I didn't check which pages were in there, but I'm assuming it's the entire discussion. So just to give that, I'll have some background as to where this came from, how this got into this case. But essentially, for issue in Wisconsin Power and Light, why it was raised in that case is that some of these comments that were filed by the party, the public comments that were filed, were filed with an envelope that had the Power and Light docket number and really no other reference to know where this was coming from, what it related to. So I just wanted BPSA to clarify which docket they intended to file these comments. And from what we heard at that hearing was that all the comments were intended to be filed in the MG&E case. So it is really the 4 filings here that I'm listing on the screen share. They're titled Public Comment by Blacks for Political and Social Action of Dane County, and then they're numbered 1 through 4 on their unearthed as public comments. So I did discuss and address the points that were made in the motion during the Power and Light hearing. But at this point, I just wondered if other parties and commission staff have a comment to make. We can ask anyone wants to chime in, go ahead. Can just go through the offered evidence list order. So if there's any comments from the applicant.
Your Honor, MG&E does not oppose the comments being included in the record. There is just one thing that we would like to clarify, though, on the record. Looking at the different dates of the documents with their PSC reference numbers, it looks like 2 were filed on September 9th. 1 was filed on September 10th at 7:38 a.m. And then we have 1 document filed on September 16th and 1 filed on September 18th. The settlement agreement was filed on IRF on September 10th at 12:30. And so really more focused on the 2 that were filed after that time, and just want to get confirmation from BPSA that notwithstanding the filing of the comments, they still support the settlement agreement.
Yeah, well, I just want to point out before we get an answer there, the comments themselves, the filing date is when staff, so these came in on the mail, in the US mail, so they weren't filed on IRF. We didn't receive them on that date. We actually received them earlier. So for that later comment, I believe there's a stamp on there. Yeah, so it's the hyper-technical world of PSC. So this was filed on IRF on September 16th, but it actually came into our office, on the 15th. Okay, so that is after the settlement. Okay, so that's one of them. And then the 18th, this 18th is, I'm not sure who filed this Deborah Green comment because there's no envelope. So I don't know if BPSA has a comment on that. They can, so I'll have them answer your question now if they wish. In terms of what we have bulleted as number 4 and 5, one's definitely was filed with an envelope that indicated BPSA, the number 4. Number 5 is a comment identified Deborah Green as the commenter, but there's no envelope, so I don't know who actually filed that. So if BPSA wants to clarify and answer MG's question about that.
Thank you, Your Honor. So to be very clear, BPSA is in support of the settlement. These written comments are not from BPSA, and in our motion we make very clear that BPSA, these are not comments that are purporting to represent BPSA or anything like that. All of these comments were filled out and made in writing at kind of other events, and then were subsequently mailed in. So to be very clear, BPSA is in support of the settlement is in support of the settlement.
Okay. All right. And just in terms of I don't know if you can see that the comment from Deborah Green, it has the appearance of the same format as the other comments BPSA filed. However, I don't have an envelope for this, so I don't know if BPSA filed it or not.
And I can't say for certain if this was mailed in by the commenter themselves or BPSA, but I believe that many of these comments were sort of premised pre-settlement agreements. So
right. Yeah, I understand from your perspective, it's not reflecting the BPSA's position on the settlement. I just didn't know if you had any idea of whether BPSA filed this one or not. It sounds like you don't know, which is fair because I don't have the envelope, so can't tell. Okay, just wanted to check. All right, so anyone else have a comment on any other parties have a response to the BPSA motion?
Your Honor, this is Daniel Narvi for Cub.
Yeah.
Cub does not oppose the motion. As to kind of the broader question of comments submitted by members of parties who are member-based organizations, such as Cub or BPSA, I just want to emphasize, I think these are important questions. It's important for a organization like Cub that has members to be able to provide information to its members about ongoing proceedings, including information about, how to submit comments. And so I think it's important that we have clarity about what is and isn't allowed in terms of providing that information. And I didn't spend enough time digesting the motion to be able to say whether I think the rules need to be changed or if they're not encompassing enough. But I just wanted to put in the record, the fact of submitting comments from members, or I should say, providing information to our members and having our members submit comments is something that's important.
Okay, thanks. Anyone else? Any other parties?
Your Honor, Commission staff has some concerns with the motion filed by BPSA on page 3.
Okay.
BPSA.
Let me get there and we can. Okay. Thanks. All right.
At the bottom. There's some concern that if there's an effort to refile comments, if these are let in, would that result in duplicate comments? We're not really sure if that effort would result in some folks having multiple comments in the process. I don't know if there's a response to that or.
So, for some context, the remedy that was proposed by Judge Newmark was to go and work with these commenters or the organizations that BPSA was working in concert with to try to contact these commenters and have them refiled. That was sort of premised on the idea that essentially the comment wasn't filed within the proper procedures, which we've kind of laid out why we think that's not correct, and that it was consistent with the FMO and the notice of hearing. But I think the premise would be that essentially these comments weren't valid, and so if they were subsequently refiled, they would be filed. The subsequent comment would be accepted, and so as kind of a boots and suspenders strategy here, we're kind of laying out why we think they should be admitted, but have BPSA has been thinking about how to kind of approach these 200 or so commenters to try to correct the case if they are ultimately going to be excluded. So that's where this footnote is in reference to.
And to the larger conversation, I think staff's position is that, we have some procedures for this. The notice of hearing allows for something like this if there's a sworn statement by the person offering the comment that explains the process by which those comments were gathered and requires that people understand that they can only file one comment at a time. The intent of that, I think, is to make sure that people are heard and that their comments are reaching the docket that they have concerns with. This case and the WPL case that Judge Newmark mentioned earlier, there's been some confusion about where comments should be going. Some envelopes were not marked or were marked in a confusing manner. Some of the comments are from folks who are outside of the MG service area. So the process sort of attempts to mitigate the potential for someone making a comment that is going to the wrong place or is not properly giving voice to that citizen's concerns. So the process as it stands is making that attempt. So I just wanted to know if that commission staff thinks that is the purpose of it, and it's clearly outlined in the notice of hearing.
Thanks. Okay, anything else from BPSA?
I think nothing further, happy to kind of clarify or discuss any of the positions and the concerns we raised in the motion. But I would just note that BPSA, none of these comments are made on behalf of BPSA. They're made on behalf of the individual commenters. BPSA's role was very, very limited here. I don't think the fact that BPSA compiled and mailed them in should disqualify these commenters from having their voices heard in these proceedings, and I don't believe violates is within a reasonable interpretation of the FMO and notice of hearing. So for those reasons, we just asked the judge to allow those comments to come in, and that'll be all from BPSA. Thank you.
Okay, yeah, thanks. So so I can give some more clarity to this and rule on the request. I think for the reasons that I discussed in the Power and Light party hearing session, the current filings are not acceptable. Still, I still believe that. I believe that, and I think that what we really want to make sure we understand is that the public comment process is designed so that I have assurance that the people making a comment are individuals speaking on their own behalf, and that the fail-safe way to do that is to have the individual file a comment directly. Either, and we make many forms of commenting available to the public for their convenience. Like I mentioned at the beginning of the hearing, you can come to the public hearing and speak a comment. You can file your comment at the hearing, or you can submit a written comment in the two ways we provided. The IRF system and by US mail. All those methods do have some form of verification. For example, presenting yourself in one form or another at the public session is one way of verifying your identity, or at least giving enough assurance that it's an individual providing a comment on their own behalf. The written comment process does include an affirmation in the web form. Also, by filing by US mail, there are restrictions for mail fraud. Basically, is where we would get the assurance that the person is truthfully filing a comment. So there's two different things. So the public comments that we received are deficient on their own merits, because I don't see the verifications. I don't see the process by which an individual has given me enough assurance that they're filing a comment on their own behalf. They're speaking on their own behalf, no matter who's filing it. There's a process by which a third party can file on someone else's behalf. That's delineated in the notice of hearing. There's no evidence that that process is followed as the filings currently appear. But the other confusing part is we have a party acting in this mix, but that doesn't absolve the individual from filing their comment the way we've instructed them to do. So the fact that the party has been inserted itself in this process, I only raised that in the Power and Light hearing to hopefully give BPSA the understanding that if they and the understanding and the opportunity to remedy the situation, because their insertion actually caused complications in the process. So I really do appreciate that footnote in the motion. If there is some affirmative step that BPSA will be taking, I'd like to hear about it. If it can remedy and get comments filed in the correct manner by the deadline, that's great. I'd love to take those comments and give them to the commission. But I did want to also speak to the duplicative nature of the comments. So whether this is an exception to the process, I don't really feel like it is, but basically, if we do get comments in on time that meet the requirements that are explained in the notice of hearing, I can just ignore the current filings. They won't go in the exhibit that I present to the commissioners in which I receive comments. And because they don't get received, they just sit on IRF, and they're not part of the record. The comments that do meet the requirements will be received and go to the commission. There will be no duplication in that sense. So just so you know, I don't consider the original comments to be valid, so they won't be duplicated if a new comment gets filed by one of the people who have attempted to file in the previous mailings. I did want to give a little background briefly about why I think this is a reasonable restriction. I know that BPSA has made some claims to First Amendment protections. I don't believe in a legal proceeding. The parties' right to speak is limited by the process by which is set up in a legal proceeding. And this is a legal proceeding. I know that BPSA commented that this is a technical issue, sort of in a negative way. But while we're lawyers and this is a technical proceeding where many things are very highly technical, we expect that people will understand that and be able to comply. But there is I think, a reasonable restriction here to the extent that an argument can be made that there's a First Amendment restriction here, which I don't believe. There's a rational reason for that, which is I need to be assured that comments are from people, they're not falsified, they're not manipulated by the filer. And I did want to draw people's attention to an order that I issued 2014 in docket 3270 UR 120. This is a case where MG&E was proposing to increase the fixed charge, and it got significant public attention and public participation in the comment process. And in that case, I received a set of filings from an organization called Consumers Energy Alliance. They offered for the record 2,500, essentially a list of 2,500 people who supported increasing the fixed charge. Did not, and this is before we had the sort of the strictures in the notice of hearing that put in place a process where I can be sure that comments are coming from individuals. The comment, this filing claimed to have comments from 2,500 users electric users in Wisconsin that supported the change to the fixed charge. However, I did not accept that filing because I did not have enough assurance that these were real comments from real people. And as it turned out in 2023, this group was found to have falsified comments in a proceeding in Ohio dealing with fracking and state parks, where 150 people believe that identities were stolen to add to the list of comments that Consumers Energy Alliance filed with it's the Parks, the Ohio Oil and Gas Land Management Commission. So so I think there is a rational reason and a purpose for having this verification process that I've set up, and the commission has approved and set forth in the notice of hearing. And if you look at the comments that we're dealing with here in this case, in the current MG&E case, those comments do not meet that standard. Therefore, I cannot accept them. I need to be even-handed in the process of filing comments, and I think the similarities here, I don't know what the intent is. I'm not saying that there's any ill intent on the people who filed or BPSA. I think you're trying to facilitate the process. I appreciate that, but there is a technical standard here, and it's meant to protect the commission and the public from abuse that we may see in other cases. I'm not saying I see any evidence of that here, but the process should be enforced. I think it's clearly explained, and if BPSA wishes to facilitate by informing the public on how to comment, that is allowed, but that we need to have comments come in from individuals. and I can be assured that they're real. I want to note in the motion. So I want to note in the notice of hearing, in this case, it does delineate that public comments filed by a third party need to come in with an affidavit verifying the process by which it was the comments were collected and by which the comments were the chain of custody of the comments should be explained. In the motion, there was an attachment from the I'm sorry, I don't know if Kirby Mack's the president or vice president of BPSA. However, it's not been verified with an affidavit. So again, it did not, even if this was to meet the standard of the notice of hearing, which it doesn't, clearly on its face, it doesn't meet that standard. And it may have had the intention of doing that, but it doesn't fix the mistake that was previously made by filing these comments on behalf of others. So in that sense, I'm going to reiterate, accept the decision I made in 6680 UR 125 at the party session. That is attached to the motion, and then in addition, the explanations I have here, hopefully that will clarify the process to the extent it needed to be, but teaches us all why we're doing it this way. And I think in terms of First Amendment restriction, I think this is a valid regulation in terms of getting protecting the process that we have. So with that, I won't be accepting the current filings. But again, the comment process is still open until October 2nd. So I encourage BPSA to do what it can within its authorized abilities here to remedy that problem. And I will accept comments that come in by that deadline, even though there were previously comments erroneously filed by those, what appears to be those people. But I don't think there'd be an issue with duplicating comments if that occurs. Okay, so one more person in here, and I think we can get started. So let's go off the record and just see if we can see how we'll handle taking witnesses at this point. Offered evidence list has bit the dust here. Wait, I think we have it. So when it comes to our MG&E witnesses, what's the plan for MG&E? Does it wish to call its witnesses? I don't think there's, first of all, I don't think there's any cross for anyone. Is that?
Your Honor, my understanding is that commission staff has cross for Andrew Eider, one of our witnesses. So obviously we will have Andy testify. But for the remaining witnesses, my understanding is there's no cross. So we would request to verify their testimony and exhibits by affidavit.
Okay. So does anyone have problems with that? A chance now to chime in. Okay, so we'll do that. We'll get on the record once we collect these all, but I think we'll be able to excuse all witnesses, MG&E witnesses, except for Eider. How about for BPSA? Any questions for Colton? No. For Cub, any questions? Or do they wish to call? I should be more clear. Do they wish to call a witness? Or are there questions for the witness?
Your Honor, we would like to have Mr. Singletary verify by affidavit and have our other two witnesses, Mr. Adams and Dr. Keim, verified today.
And let me ask BPSA one more. Did they wish to call Colton to verify or to have any additional?
We would submit an affidavit for Mr. Colton.
Okay.
Thanks.
IBEW, I can have you verified your testimony today, live, or you can file an affidavit. It's up to you.
I can verify that testimony today.
Okay. And Renew.
Your Honor, Renew would like to verify our two witnesses on the stand today.
Gotta get my color right now. And Weeg.
Yes, Your Honor, we would like to submit an affidavit verifying the testimony.
All right. And commission staff, you'll be calling your witnesses.
That's correct, Your Honor. We'll verify in the stand today. Thank you.
All right. Did I miss anyone? Okay, so let's get on the record. So let's see. I'll try this. Correct me if I'm wrong. It looks like for the applicant, we can receive the current documents once they're verified by affidavit. For witnesses Bates, Deneau, Heidel, Monroe Nye, Pennington, Roan, and Rob, testimony will be verified by Monroe Nye, Schmidt, Schmudlich, Scholler, and Smith.
Correct, Your Honor.
Okay, thanks. For BPSA, we will take Colton testimony by affidavit. So Cub, Adams, and Kime will file by affidavit. Renew.
Sorry, Your Honor, it's the reverse. Mr. Singletary will verify by affidavit.
Okay, yes, thanks. So we'll excuse Adams and Kime. Rasmussen.
No, sorry. Mr. Singletary will submit by affidavit, so we have for him to be excused. Mr. Adams and Dr. Kime are prepared to verify through testimony today.
Okay, right. Belkey and Kell, we can excuse. We'll file by affidavit.
Your Honor,
You're
that was
calling.
on the stand.
I was on the stand. Okay, so we'll take Kell
Thank
and Belkey and Stevens. We will excuse Weeks witness. Okay.
Yep, thanks.
Okay, yeah, there we go. It's okay. So why don't we get started then? First of all, I can verify the IBW witness before we. Well, let's just go in order. There's not that many. So let's start with Eider and have let's call Eider for the for verification and for questions. Oh, I see you there. All right, let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Please state your name and position for the record.
Andrew Eider, and I'm a rate analyst.
Mr. Eider, did you prepare and submit direct testimony and rebuttal testimony in this proceeding?
I did.
And Mr. Eider, with your testimony, are you also sponsoring 6 exhibits in this proceeding?
Yes.
Were the 6 exhibits prepared by you or under your direction?
Yes.
Is the content of your testimony in the exhibits that you have sponsored still true and accurate as of the date of today's proceeding?
Yes.
Your Honor, I do not have any additional questions. Mr. Eider is available for cross-examination.
Okay, so I think staff had questions.
Yes, that's correct. Good morning, Andrew. My name is Michael Garcia, and I'm with Commission staff. I just had a quick clarifying question for you. Your Honor, could you bring up direct MG Eider?
Yes.
And then page 15, starting at line 20.
If you have it, you can also use the screens a little.
I think that's it.
Yeah, I don't think it'll be necessary to have in front of you, but that way the commission will be able to find it in the transcript. Andrew, the initial proposal you described there was for MG and E to remove some options by which customers could apply for gas service. Is that correct?
Correct.
And does MG&E still intend to make that change to their application for service language?
No. Under the settlement agreement, MG&E's application for service language for both electric and natural gas will remain unchanged from its currently authorized language. The red lines submitted in the settlement application are complete, and the settlement agreement application includes the electric service rules and regulations, general information sheets, because there are proposed changes within those sheets. However, none of those changes relate to the application for service. And the application for the settlement does not include the gas rules and regulation general information sheets because there are no proposed changes within those sheets.
Thank you, Andrew. That is all I had, Your Honor.
Okay, great. Thanks. Any redirect?
No, Your Honor.
Okay. Thanks. You're excused.
Thank you.
And you can move on to. Okay, I got my colors wrong here. So Colton, we were gonna do by affidavit, right? Yeah, okay.
Yes,
So
thanks.
why I messed that up. Okay. Cub, let's go to Cub with our witnesses who are taking the stand. Go ahead.
Thank you. Cub will begin with Mr. Jeff Adams.
All right, I see you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead.
Mr. Adams, can you state your name for the record?
Jeff Adams, ADAMS.
Did you submit direct testimony in this proceeding?
Yes, I did.
Is the information in your written testimony truthful and accurate to the best of your knowledge?
Yes, it is.
If I asked you the same questions that appear in your testimony today, would your answers be the same?
They would be.
And no further questions for Mr. Adams?
All right, any cross? No. All right, thanks. You're excused.
Thank you.
Cub's second and last witness today is Dr. Steve Keim.
Okay, see you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Good morning, Dr. Keim. Could you state your name for the record?
Stephen Keim, K-I-H-M.
Dr. Keim, did you submit direct testimony along with exhibits numbered 1 through 5 in this proceeding?
I did.
Is the information in your written testimony and exhibits truthful and accurate to the best of your knowledge?
Yes.
If I asked you the same questions that appear in your testimony today, would your answers be the same?
Yes.
No further questions for Dr. Keim.
Okay. Any cross? No? You're excused. Thanks.
Thank you, Your Honor.
Okay, so we'll move on to IBEW with Nathan Rasmussen. I got you on the screen there. Just unmute. Great. All right, I'll swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Just state your name for the record.
Nate Rasmussen.
All right, and you're with the IBEW Local 2304?
Yes, I'm the president and business manager.
Thanks. And you filed direct testimony and 1 exhibit, is that correct?
Yes.
So are those documents complete and correct to the best of your knowledge?
Yes.
Do you have anything you'd like to add as a final statement from what's been filed most recently in the case?
No.
Okay, thanks. All right, any questions for witness Rasmussen? Nothing? All right, thanks very much. You're excused.
Thank you.
Okay. Skipping over. No, we're not skipping over renew.
Thank you, Your Honor.
Got my color wrong. Okay. Go ahead and call your first witness.
Thank you, Your Honor. Renew calls Ben Belke to the stand.
I see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Mr. Belke, can you please state your full name for the record?
Ben Belke, B-E-H-L-K-E.
Mr. Belke, did you prepare and file or cause to be filed direct testimony and 7 exhibits?
Yes, I did.
If I asked you the same questions that appear in your written testimony, would your answers be the same?
Yes.
Is the information in your testimony and exhibits complete, correct, and truthful to the best of your knowledge?
Yes.
Your Honor, Mr. Belkey is ready for cross.
Okay, any question? Hearing none, you're excused. Thanks.
Thank you.
Your Honor, Renew calls Andrew Kell to stand.
All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Go ahead.
Mr. Kell, can you please state your full name for the record?
Andrew Kell, Kell.
Did you prepare and file or cause to be filed direct testimony and 3 exhibits?
Yes, I did.
Is the information in your testimony and exhibits complete, correct, and truthful to the best of your knowledge?
Yes, it is.
Your Honor, Mr. Kell is ready for cross.
All right, any questions? Hearing none, you're excused. Thanks very much. Okay, so we're skipping over Weig, and we'll go right to commission staff.
Thank you, Your Honor. Your Honor calls witness Adams to the stand.
Okay, I see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
Please state your name for the record.
It's Justin Adams.
Did you prepare and file or cause to be filed direct testimony and 1 exhibit in this docket?
I did.
Are the statements and representations in the testimony and exhibit you filed in this case true and correct to the best of your knowledge?
They are.
And do you have any additions or modifications to your testimony or exhibit at this time?
I do not.
Your Honor, the witness is open for cross.
Any questions? Hearing none, you're excused.
Thank you.
Your Honor, the commission calls witness Clark to the stand.
Hi there, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
We're taking Clark first.
Say again. Please state your name for the record.
Chastity Clark.
Did you prepare and file or cause to be filed rebuttal testimony in this docket?
Yes.
Are the statements and representations in your rebuttal testimony true and correct to the best of your knowledge?
Yes.
Do you have any modifications or additions to your testimony at this time?
No.
All right. The witness is open for cross.
All right, any questions? Hearing none, you're excused. Thanks very much.
The commission calls witness Colvin to the stand.
Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, go ahead.
Please state your name for the record.
Tanya Colvin.
Did you prepare and file or cause to be filed direct testimony and 6 exhibits in this docket?
Yes.
And you will also be presenting the staff exhibits, correct? The data request exhibit and the delayed public comments exhibit?
Yes.
Are the statements and representations in the testimony and exhibits you have filed in this case true and correct to the best of your knowledge?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
No.
The witness is open for cross.
Any questions? Hearing none, you're excused. Thanks very much.
The commission calls witness Corbeil to the stand.
All right, see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Please state your full name for the record.
Lauren Corbeil.
Did you prepare and file or cause to be filed direct testimony and 1 exhibit in this docket?
I did.
And you will also be filing a 2nd delayed exhibit, correct?
Correct.
Are the statements and representations in the testimony and exhibits you have filed in this case true and correct to the best of your knowledge?
They are.
Do you have any additions or modifications to your testimony or exhibit at this time?
Yes, I'd like to address the statement release that MISO had identified a software error while calculating the PRA auction pricing for the 2025-2026 planning year. Commission staff will be including this updated pricing in the final model run for the applicant, and those results will then be included in the delayed exhibit Corbeil 2.
The witness is open for cross.
Okay, so I just want to make sure we mark that Corbeil 2 exhibit, exhibit PSC Corbeil 2, the fuel cost update exhibit. Just verify that for me, witness Corbeil. That's the correct way to identify your second exhibit.
Yes.
Okay, thanks. All right, and with that, we can ask for questions. Any cross for the witness?
Your Honor, Steve Heinzen for Weig does have some cross.
Okay, go ahead.
All right. Good morning, Steve Heinzen for Weig, and I have a question for you in connection with I don't know, the error that you have learned about from MISO with the PRA auction.
Yep.
Do you have an idea right now of how significant of a change in the fuel cost that error is on MG&E's, I guess, the exhibit that has been filed up to this point?
No, I do not. Numbers were not run. We haven't given any updates to MG&E at this point. Those numbers will all shake out at the final model run.
Can you, I guess, speculate as to whether that error could run in the neighborhood of millions of dollars?
I don't know.
Okay, I think there would be an objection. Maybe just rephrasing your
Well, sure. The settlement agreement is, it's pretty critical for the settlement agreement what the I guess what the fuel costs are, because it touches upon the entire revenue requirement. And it would be helpful to know now whether the dollar amount from this error is material.
The dollar amount may be material. I cannot calculate that. That would be something that the applicant would wind up having to run through their model run to get an accurate number.
Okay, thank you.
Okay, yeah, it's yeah, I guess we'll leave it at that. Okay, any other cross? How about redirect?
None.
Okay, thanks. Okay, all right, so at this point, you're excused. Thanks very much.
Thank you.
Your Honor, the commission calls witness Horry to the stand.
See you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes.
Okay, go ahead.
Please state your name for the record.
Mitch Horry.
Did you prepare and file or cause to be filed direct testimony in one exhibit in this docket?
Yes.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct to the best of your knowledge?
Yes.
Do you have any additions or modifications to your testimony or exhibit at this time?
No.
The witness is open for cross.
Any questions? Hearing none, you're excused. Thanks.
Your Honor, the commission calls witness Mielemans to the stand.
Okay, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, go ahead.
Please state your name for the record.
Tyler Mielemans.
Did you prepare and file or cause to be filed direct testimony and 4 exhibits in this case?
Yes, I did.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct to the best of your knowledge?
Yes, they are.
Do you have any additions or modifications to your testimony or exhibits at this time?
I do not.
Your Honor, the witness is open for cross.
Any questions? Hearing none, you're excused. Thanks.
Your Honor, the commission calls witness Upoff to the stand.
There you are. Just unmute.
There you go.
Okay, great. Raise your right hand. Do you swear or affirm tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record.
Evan Uphoff.
Did you prepare and file or cause to be filed direct testimony in this docket?
I did.
Are the statements and representations in the testimony you filed in this case true and correct to the best of your knowledge?
Yes.
And do you have any additions or modifications to your testimony at this time?
I do not.
The witness is open for cross.
Any questions? No? Thanks very much. You're excused.
Your Honor, the commission calls witness Wu to the stand.
There we go. Raise your right hand. And do you swear or affirm tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Please state your name for the record.
My name is Cheng Wu.
Did you prepare and file or cause to be filed direct testimony and 6 exhibits in this docket?
Yes.
Are the statements and representations in your testimony and exhibits filed in this case true and correct to the best of your knowledge?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
No.
Your Honor, this witness is open for cross.
All right. Any questions? Not hearing any. Thanks very much. You're excused. So I did want to just that's the balance of commission staff's witnesses. Is that correct?
That's correct, Your Honor.
Okay. So I guess was kind of surprised by the questions from Attorney Heinzen. I think maybe we just want to clarify the process we're taking now. And I don't recall, I know this, well, maybe Attorney Heinzen can also comment about whether this has an impact on the power and light fuel rate case. It's also been settled by the parties. And how, I mean, what are we facing here? Just give me like kind of a layout of the landscape here. If there's going to be a complication as we get down the road in these cases.
Your Honor, if you might remember, I did ask a question similar to this at the Power and Light. I've got an answer that was similar to this. And so my sense was from Power and Light that the correction or the mistake was not substantial. I'm not sure what substantial is, but not substantial. I had a little bit less certainty here. Certainly there was a pretty significant change in the fuel costs after the staff's audit here. I think a greater change than was the case in Power and Light. But certainly in both of the cases, the revenue requirement includes the fuel costs. And I know that, everybody knows that the fuel costs can be updated near the very end of the case. But if we know right now that there is a significant change in a piece of that is not typical, which would be, there's a mistake in the PRA. I don't know, the sooner we have that information, certainly the better.
Okay. Yeah. I mean, because we have a combined contested case process and a settlement process kind of running together parallel. That does kind of put us, make this a little more procedurally challenging, I think, when it comes to I don't know exactly what form it would take if we had an issue then with the ultimate settled rates that are being proposed in the settlement. At what point in time you'd need to express that, and at what point in time Corbeil 2 will be available. That's just something, you'll just need to address that in the future, I suppose. But
yes, thank you. So so that's where we're right now. It would be, particularly helpful if this is not a particularly significant, correction. to know that. And then that's certainly going to have, it would then have very little, folks would not be concerned about it. I would think it was just, some minor mistake. And so and the sooner we would know that, the better off I think we would probably all feel about both cases.
Okay, okay. So you need to, so it's the model runs that would tell us what the impact is, and you're asking to have that, it sounds like your preference or suggestion would be to get that out as soon as possible.
Yes, that would be very helpful. Yes.
Okay. All right. Well, probably the most I can do at this point, but I just wanted to make sure that everyone's understanding Weeks' position here, and the concerns that you raise here. And I guess to the best of your knowledge, it just seems a little different than in Power and Light. It seems like it may have a more significant impact in the MGE.
And I base that simply on the significant, I think it was, I don't know, $8 or $9 million change from the audit that was tied to the PRA, if I'm not mistaken. And so it's a significant dollar amount that I don't think was the case in Power and Light.
Okay. All right. So anyone else want to comment on that? Just wanted to air that before so there's no surprises.
Yeah, I'll just say for Cub, we have the same interest in getting that information as soon as we can. So appreciate Steve's comments.
All right. So I don't know if we have all the evidence we're here to collect. And we will be reconvening or opening the public session September 30th, as our notice indicates. Besides that, I think we have everything we need to covered today. Is there anything else we need to address before we adjourn?
Not from the applicant standpoint. Thank you, Your Honor.
Okay. Anyone else? No? All right. Well, thanks very much, everyone. We're adjourned.
Thank you. Thank you.
Thank you.
Thank
Thank
you.
you, Your Honor.